The next argument is Commonwealth of Pennsylvania versus Jordan Adonis Rawls. Representing Mr. Rawls is Mr. Edward J. Rimsa. Representing the Commonwealth is Mr. Martin L. Wade.
Good afternoon. An armed robbery led to the deaths of two individuals inside their Williamsport, Pennsylvania home. After an initial investigation and implicated petitioner, the Williamsport police charged him with 2 counts of criminal homicide related offenses. After seeing his name and photographs circulated in the news, petitioner presented himself at a police station where he was placed under arrest and questioned by the police. He waived his Miranda rights and then confessed to participating in the robbery. However, the police did not tell him that criminal charges had already been filed against him. The issue is whether, before asking him to waive his Miranda rights, the Sixth Amendment to the United States Constitution required police to tell petitioner that criminal charges had been filed against him. We hear from Mr. Rimsa.
Good afternoon, Mr. Chief Justice, and may it please the court. 35 years ago, this court recognized in a case called Commonwealth versus Karish that a valid Miranda waiver will not necessarily waive the right to counsel under the Sixth Amendment. The case against Jordan Rawls is one of those rare cases where that rule applies. Because in this case, Mr. Rawls was interrogated by the police for approximately 5.5 hours after he had already been formally charged the day before with 2 open counts of criminal homicide. Police in this case not only deliberately failed to tell Mr. Rawls that he had already been formally charged by way of a criminal complaint, but they actively and intentionally misled him into waiving those Miranda rights that they had given him, knowing full well that nothing he said at that moment was going to undo the criminal charges that have already been filed against him. As a result, under the facts of this case, when the Sixth Amendment right to counsel has already attached, something more than just Miranda warnings are required when the police intentionally failed to disclose that criminal charges have already been filed. And I want to be very clear, what we're asking for in this case is really nothing novel. The Karish court recognized that Miranda waivers won't always be enough. 2 years later, in 1988, the United States Supreme Court, in a footnote, addressed this issue in Patterson versus Illinois, that recognized that there will be cases where a waiver under Miranda will not suffice for Sixth Amendment purposes. And certainly other courts, we cited in our opening brief, other courts have cited and relied on their own constitutions, their state court constitutions, to determine that Miranda warnings are an adequate substitute for post-indictment interrogations. Also, in the past, this court has taken similar steps when the court felt there was a need for clarity in obtaining a valid Miranda waiver. There were 2 cases in the 70s, Commonwealth versus Richmond and Commonwealth versus Dixon, where the court at that point addressed the issue of whether valid Miranda rights, a waiver, whether there could be a valid waiver if the suspect didn't know the nature of the charges against him or her. And certainly nowhere in Miranda does it say that the police have to advise a suspect of the nature of the investigation. But this court in those 2 cases certainly saw a need for it and made those changes in those 2 cases. So again, we don't think we're asking.
Justice Baer, at the beginning of your presentation, and I didn't want to interrupt you because we try to allow you to get a few minutes in and to explain your generalized position. You said that the police, and I'm paraphrasing you because my memory is not what it once was, but the police were not candid or engaged in some trickery in terms of their candidness to the defendant. And when I read the facts, and I appreciate that there's no bright line between the Fifth and Sixth Amendment, and sometimes the Fifth Amendment will suffice, Miranda, and sometimes it will not. When he got to the police station, he was arrested. He was put in both handcuffs and foot cuffs and put into an interrogation room. So that would convey, it seems to me, to most actors that you're in a lot of trouble, that the police scrutiny is focused on you, and therefore, although they didn't inform him of a criminal proceeding, that he either knew or should have known that there were criminal proceedings on their way. So what did the police do, in your estimation, to trick him into waiving under the Fifth Amendment, which he could not have done under the Sixth Amendment?
So, Your Honor, I don't think without telling Mr. Rawls that he had already been criminally charged by way of a complaint, and the process was going to continue, and the charges were going to continue with or without his cooperation, is something that I believe that the Sixth Amendment would have required, and that was a very, very important fact that the police intentionally left out. Simply just because he was under arrest by itself. An arrest warrant is certainly different from a actual criminal complaint where adversary proceedings have already begun. But certainly people can get arrested and then later released, or charges never actually even come as a result of that arrest. And I think in terms of how they misled him, they told him things, once they read him Miranda warnings, I think the things they said to him, things like, we're only investigating this case, that there may be some middle ground. They wanted to hear his side of the story. And my particular favorite, when they said, we don't think you'd come bouncing in here if you were the guy responsible for this. I mean, those were things that they falsely suggested that if he talks, that it would somehow improve his situation. And in fact, I think what they said was absolutely incompatible with Miranda, incompatible with anything you say will be used against you, and that you have the right to remain silent.
So you're not arguing for a bright line rule in Pennsylvania that once criminal proceedings have begun, to use the Sixth Amendment language, police must always provide counsel, regardless of Fifth Amendment, etc. You're arguing under these facts and circumstances, this can fall under Patterson and the other cases you mentioned.
Well, yes, but again, in Patterson, in footnote 9, it talks about that Miranda waiver won't always be enough. I think in this case, what needed to be communicated to Mr. Rawls, however they did it, were really two additional points. One was that charges, Mr. Rawls, have already been filed and initiated against you. And no matter what you say here today, the case is going to proceed against you.
I don't know about the second part, but why wouldn't you want a bright line rule to make the waiver informed? Say, look, charges have already been filed. I don't know what else you'd say, but you know, the rest of the stuff. But don't you want a bright line rule?
Well, Mr. Chief Justice, I of course, it's always a little bit dangerous asking for that bright line rule, but I certainly think that under the facts presented in this case, that once the Sixth Amendment had attached, that they were obligated to let Mr. Rawls know the situation, so him to be able to appreciate the magnitude of his situation.
Any other questions or any other argument? It's a pretty straightforward argument.
It's Justice Donahue. I have just one question. Does your position rest on the proposition that the Sixth Amendment right to counsel attaches once the criminal complaint is filed? Yes.
And I think the McCoy case addressed that. I know the Commonwealth took some exception to that, but certainly even under United States Supreme Court precedent, Kirby versus Illinois, indicates that the initiation of the adversary proceedings by way of a formal charge triggers the Sixth Amendment right to counsel,
which can be waived. Which can be waived.
Which can be waived, Chief Justice. But again, I think that there is a clear distinction between the Fifth and the Sixth Amendment. We outlined that in our brief, that they serve completely different purposes, particularly when the Sixth Amendment attaches automatically, and it's designed to cast a broad net. We're certainly not suggesting that it deserves more reverence than the Fifth Amendment, but it does attach automatically, and in essence gives the accused a shield when they deal with post-indictment adversaries through counsel. And certainly, Miranda is in my view is inadequate. It was never designed to be a substitute for the Sixth Amendment. It only applies to custodial interrogations. In fact, the Fifth Amendment doesn't even reference a right to counsel.
And counsel, your position would then be that he could not possibly have waived his Sixth Amendment right because he didn't know he had it.
Right.
Okay.
Counsel, I have one question. Considering this is a waiver issue, what level of deliberation or consideration should we attribute to the prior criminal history of the person asserting a constitutional violation?
I think, Your Honor, that it really does. The fact that Mr. Rawls had some prior criminal history may be relevant, but again, when he was, it may be relevant to a certain degree, but he didn't know at that point that charges were definite. I don't know the circumstances of his prior case, if he was well aware that how the adversary process goes, whether or not he was, whether there were statements made in that case, whether there was custodial interrogations. So I think the facts may be a bit different. He certainly wasn't a novice. I'm not suggesting he was. I think his only prior contact at the time was a prior robbery conviction when he was around 18 or so. So again, I don't think also you can attribute the fact that he was arrested in this case. People can be free to go after they're arrested. Another thing that I think is a little bit distinguishing in this case that can't be overlooked was what the police told him. Even though they gave him these Miranda rights, they then undermined them by the things they said. And I think that's very, very critical in this case. And I think it's dispositive.
Thank you. Here from the Commonwealth.
Thank you, Mr. Chief Justice, and may it please the court. I'll be relatively brief. I just wanted to start out with a hypothetical. If Mr. Rawls was arrested a block away from the crime scene minutes after the shooting with a 9mm handgun in his pocket, the victim's wallet in his pocket, and the victim's blood on his hands, he naturally would have been handcuffed, arrested, taken to the police station. Had he been read the exact same warnings in this case, word for word, with the exact same procedure, and confessed, we certainly wouldn't be here today, even if a fellow officer was just next door in the next interrogation room typing up his charges as he confessed. And the warnings that were read to Mr. Rawls articulate the severe consequences of speaking without counsel with equal force, regardless of whether they're administered pre or post indictment. The accused in both situations is advised that if he speaks, the end result will be the same, resulting in a stronger prosecution and a greater likelihood of a conviction.
Let me interrupt you there, counsel.
Yes, sir.
Sort of put the bunny in the hat by assuming that the that sort of big waving red flag there is not relevant to the defendant, or that the defendant doesn't need to know this very germane fact. Let me ask you, your amicus, the DA's Association, tells us that the right to counsel does not attach for Sixth Amendment purposes until the defendant is brought in front of a judicial officer. Do you agree?
No, I don't.
Okay,
No,
what's your view then? What is your view?
I agree with the Superior Court. I think they found that it attached with the filing of formal charges.
So going back to your hypothetical, counselor, at what point, if the person was caught with all the evidence and he's brought in At what point would you have said, at what point during that custodial interrogation would his Sixth Amendment right attached, since there was no commencement of an adversarial proceeding?
Once charges were filed, I would say.
So your position that a Sixth Amendment has to be invoked as opposed to being cloaked at the moment of adversarial proceedings?
My understanding of the entire defense position is that it doesn't attach until the charges are filed. So
Correct. And charges were filed in this particular case.
in this case, yes.
So under Miranda, for the Fifth Amendment, nowhere in the Constitution, as counsel indicated, nowhere in the constitutional writing of the Fifth is there a right to counsel. The right to counsel via Miranda is judicially created. Yet the Sixth Amendment clearly gives them a right to counsel and judicially created mandate that it begins at some type of criminal episode. So I guess the question I have is, how is it that in this particular scenario, we have an individual who is not aware that a criminal charge had come against him such that he was no longer a suspect, but he was the target of the Commonwealth's strength, and yet he was not advised that he was now a defendant and not a suspect? Doesn't that change the playing field as to his constitutional protections mandated by the Sixth?
I think his Sixth Amendment certainly attached, and that's why it was incumbent upon police to read the Miranda warnings, which advise him of his right to counsel.
Mr. Wade, what possible reason would there be for not telling him he had been charged?
I honestly don't know, Mr. Chief Justice, other than there was no such requirement at the time.
But it would seem to me common sense would make it a more informed waiver. You just say, look, you have these rights, and by the way, you've been charged with a crime. Now you want to talk.
Certainly, if he had been told that, we wouldn't be here. But I think he was given a lot of other information, such as being told that he was under arrest for his involvement in a homicide, the chains that Justice Baer referenced. We know that he was aware that the shooting resulted in the death of 2 people before he came to the police station. So I think he was fully aware that he was the target of this investigation and that he was under arrest and not free to leave due specifically because of his criminal misconduct in that particular incident.
Thank you. Okay, fairly straightforward. Anything else, Mr. Wade?
All I wanted to say, just what I initially started saying, is that I believe that he was fully aware of the consequences of waiving his right to counsel, just as aware as he would have been under my hypothetical situation. And under my hypothetical, there would be no constitutional violation and we wouldn't be here. And so I think the information in both instances is the same. He's told that it's not a possibility, it's a guarantee. It will be used against you in court. And due to his criminal history, I think he understood the implications of that more than a novice might understand. And I do want to add that I think the collective weight of the persuasive authority that I referenced in my brief certainly does weigh in favor of affirming the sentence in this case.
Yeah, certainly the weight of federal authority seems to be in favor of your position. And the states that have departed, I think, have referenced their respective constitutions, but you've not invoked Pennsylvania Constitution, as your brother, the has not. So thank you.
Thank you, Mr. Chief Justice.
Take a brief pause and then we'll call the next case.
The next argument is U.S. Venture Inc. versus the Commonwealth Department of Community and Economic Development. Representing the Commonwealth, representing U.S. Venture is Mr. Michael F. Nerone. Representing the Commonwealth is Mr. J. Michael Adams, Jr.
Good afternoon. In this appeal, the Department of Community and Economic Development awarded grants to Aplt to assist in constructing natural gas fueling stations in the Commonwealth. But when the department refused to reimburse Aplt for allegedly failing to abide by the grant agreement, Aplt filed an action with the Board of Claims, which resolves disputes arising from contracts with the Commonwealth. However, the board may not hear claims related to grants unless the grant's primary purpose was to procure construction to the grantor. Construction is defined by the Procurement Code, includes assembling any public structure or building. The controversy at issue centers on whether public means publicly owned or publicly accessible. Mr. Nerone.
Thank you, Mr. Chief Justice, members of the court. I want to start with the Commonwealth Court's opinion on page 11. The court says, nonetheless, the aforementioned cases support petitioner's contention that its interpretation of statutory language is plausible. They cite the Nardone case. Accordingly, this court concludes that the phrase public structure or building in section 103 of the Procurement Code is ambiguous. And neither party in the present appeal to the Supreme Court has challenged this holding. We believe that the Commonwealth Court is absolutely correct that section 103 of the Procurement Code is ambiguous. But why we're here, what we think the mistake was by the Commonwealth Court is if you read through the balance of its opinion from page 11 through page 17, nowhere is there any analysis of the Statutory Construction Act, section 1928B7, and or the seminal decisions of Hanover, Telwell, DataQuest, and or Scientific Games affirmation that Hanover, in fact, is the law of Pennsylvania. And we think as a result, the court came to the incorrect conclusion. And quickly, section 1928B states all provisions of a statute of the classes hereafter enumerated, and I want to emphasize this, shall be strictly construed. Subsection 7 under B is provisions decreasing the jurisdiction of a court of record. We believe this section directly governs the controversy at hand, meaning that unless there is explicit language in the statute saying that jurisdiction does not attach, strict construction mandates that this court and or the Commonwealth Court should have concluded that jurisdiction exists. And
Counsel, it's Justice Donahue. I'm sorry to interrupt your opening, but you just addressed a point that I'd like you to clarify. Is the Board of Claims a court of record?
It is, Your Honor, yes.
And your authority for that?
I don't have anything to cite to you except that I know that that is I apologize. I should have been prepared for that question, but I do believe, yes, it is a court of record because any appeal from there goes to the Commonwealth Court. It is the court of original jurisdiction in this case.
Why is it a court? I'm probing the issue. I don't know the answer to it. And I haven't seen any discussion in either of the briefs of that particular point. You rely so heavily on that proposition. I'd just like to probe it. It's certainly not a court that's delineated in Article 5. Yet, yet on the other hand, Article 5 allows the General Assembly to create new courts. But my question is, if they were going to create a court, why wouldn't they call it a court of claims?
I don't know the answer to that, but it's the Board of Claims, and it does everything a court does. It takes evidence, it makes rulings. In fact, most of our rules of civil procedure apply before the Board of Claims. So I didn't see any challenge to that from anybody along the way. I firmly believe it is a court of record. It's the court where the findings of fact are made, and then to the extent there are legal issues, they go up on appeal. I don't know how we would call it anything but a court.
But what you just described, counsel, is also true of the Workers' Compensation Appeal Board. They generally abide by the rules of procedure. They generally abide by evidentiary rules, more or less. There's an appeal as of right from that tribunal. To me, it's an open question, but I'll accept your proposition for the sake of argument. How do you align that presumption or that maxim that you'd like us to apply with the maxim that we generally apply in cases involving sovereign immunity, which in shorthand requires us to interpret in such a way so that the immunity applies? Because this is really a sovereign immunity case, correct? I mean, that's really at the bottom line what this is about.
I would respectfully disagree that this is a sovereign immunity case, and I would distinguish this case from Scientific Games, which was a sovereign immunity case. I understand and recognize and acknowledge that sovereign immunity here is commensurate with jurisdiction, meaning if jurisdiction exists, then there's no sovereign immunity. There's been an express waiver through 1702B. However, if you analytically look at this, we can never get to the sovereign immunity issue if there is not subject matter jurisdiction. Subject matter jurisdiction necessarily comes first. If a court doesn't have subject matter jurisdiction, then it doesn't have the power to adjudicate anything, and anything that it does attempt to adjudicate is void under the precedence of this court. So yes, I believe this is a jurisdictional case, not a sovereign immunity case. The distinction being in Scientific Games, the claimant there sought original jurisdiction in the Commonwealth Court rather than the Board of Claims. And when the issue comes up to this court, the only grounds for dismissing that suit was sovereign immunity. And that's why it's the flip side of the same coin, kind of. So it stops claimants like my client from filing in the Commonwealth Court or in some other forum. The Commonwealth is immune in those forums. The sovereign immunity being commensurate with jurisdiction of the Board of Claims funnels us all into the Board of Claims where the legislature wanted these claims to be adjudicated. So that's how I square, and I acknowledge that there are certain interpretation rules that go when it's a sovereign immunity case, but I would submit to you wholeheartedly here that this is not a sovereign immunity case. It is a jurisdictional issue, and that's why Section 1928 and the language shall be strictly construed causes the Commonwealth Court to have been mistaken in its analysis.
But I guess I'm struggling with your distinction, because the Board of Claims exists to adjudicate or hear cases where the General Assembly has waived sovereign immunity, correct?
Yeah, yes and no. The General Assembly has waived sovereign immunity in 1702B, and they make express reference to 1712.1, which is the procedural section of the procurement code for pursuing claims in the board before the Board of Claims. So I believe there's been an explicit waiver where jurisdiction is found, but I believe to be logically and analytically consistent, the court has to address the jurisdictional issue first before it would touch upon sovereign immunity. And in this case, once you resolve the jurisdictional issue, sovereign immunity essentially is a collateral estoppel, which would be worked because it's if the Board of Claims has jurisdiction, then sovereign immunity does not apply. It's been expressly waived.
Okay, thank you.
Counsel, it's Justice Baer. Can you hear me?
Loud and clear.
All right, good. This is about the procurement code. Implicitly, that means that the Commonwealth is attempting to procure something. You know, in 102F, grants don't count unless they're to procure construction. And in 103, are we building a public structure or doing something to public real property, etc.? Under the facts of this case, and I wasn't sure the case should get here, respect to your client, they leased private property. They leased equipment that they put on private property, if I understand this correctly. So I don't see how they fall. I'm not even sure I see an ambiguity where the procurement code and the Board of Claims and the Commonwealth's interest in procuring building or improvements on public structures or to public real property have anything to do with the case where for whatever reason, hopefully they made money, your client leased private property and took leased equipment and put it on there to run the business.
I believe those facts, Your Honor, are at issue. We did not concede, and I believe if you go back to our statement of claim, you'll see that we expressly denied. The document may have been titled lease, but I believe it was just a financing mechanism where the equipment was owned at the end, and we saw that as an issue that was going to be adjudicated before the Board of Claims. More broadly, and I think your question is really more broadly, why are we looking at this issue under the procurement code? And my answer to that is that the Commonwealth was purchasing clean energy infrastructure through a public-private partnership here. As a practical matter, clean energy is a catch-22 because until you have the vehicles on the road that can use this type of clean energy, it doesn't make financial sense for people like my client to develop fueling stations. There's nobody there to buy the fuel. And conversely, nobody's going to put vehicles on the road that burn that type of fuel until there's the infrastructure. So it can't happen unless the government gets involved. And so from a public policy basis, I'd urge the court that the Commonwealth was making a very real purchase here of clean energy infrastructure. I think the goal here is at some point to move completely away from burning petroleum in our cars and burning cleaner energy, and maybe one day even moving from that. But in the very truest sense, I believe there was a procurement here, Your Honor.
Well, and that gets you back to the beginning, and I appreciate that answer. Is it your client's position, and is it a contested issue in this case, which I may have misunderstood in going through this, that you in fact are doing some sort of building or improvement to the state's real property as opposed to private property?
No, and I didn't mean to mislead the court. This is all private property. Everything is privately owned. It is open to the public. Therefore, we believe it is public building, public structure.
So let's back up because and I know it's not intentional, but I think I got two separate answers. I want to know which answer is correct. Are you in fact taking private land, taking leased equipment and putting it on the private land to run your business? Or conversely, are you taking public land, land that's not that's accessible to the public? You know, the big department store or mall is accessible to the public. The airport's accessible to the public. The boatyard is. Are you taking public land as opposed to something accessible to the public and improving it?
We are not, Your Honor. It's private land. The part of your question that I took issue with was the leasing issue. I disagreed with that, but no, this is all private land. It's open to the public.
Is the equipment that you're putting on this private land going to eventually be titled to the Commonwealth under your theory of the case?
It is not, Your Honor.
All right, so your whole, okay, then I didn't understand the case correctly. Your whole case rises or falls on the theory that if the public can access, everything's public land. There's hundreds of thousands of acres of public land. And your theory would be if you put some leased equipment on it, you somehow fall under this. Doesn't the procurement mean the Commonwealth's procuring something?
Well, and that's why I tried to answer the question, because I saw where this was leading, and I do believe the Commonwealth is procuring something. They're procuring clean energy infrastructure, and this is the only way it's ever going to happen. And from a policy standpoint, if they stiff people, and forgive my verbiage, but that's the way my client feels, you're not going to have contractors lining up to build these projects. They're going to go to other states, and we're not going to have clean energy available.
And counsel, I don't want to dominate this, so let me try to make this my last question. Why? Because we don't want your client stiffed. We're the Supreme Court. We want to try to do justice. Why is this the only way this can happen? Private property, private lease agreements to produce this?
Because the state doesn't want to take on, I imagine if the state chose, it could start opening up fueling stations, but I don't think the state wants to do that, Your Honor. I don't think they want to operate them. They don't want to take on the liability. They don't want to deal with all the headaches that go along with operating a fueling station of that nature. But I think the state very much wants that infrastructure here in Pennsylvania. That's my answer to your question.
And that's a fine answer. Thank you very much. We'll listen to what the other side has to say about all of this.
Okay. Couple of additional points I wanted to make. The Commonwealth Court relied almost exclusively on Section 1921 of the Statutory Construction Act. And what I wanted to point out to this court is the section that the Commonwealth Court and the Commonwealth in this case relies on states when words of the statute are not explicit, the intention of the General Assembly may be ascertained by considering among other matters the former law, if any, including other statutes upon similar subjects. This is not mandatory. This said may. Section 1928 says shall. And so I would submit to the court that there has to be some rationale under 1928 and strict construction in the case law that's developed under that that would mandate a finding against me. And I'm struggling to see how that could happen. When we delve down even further into Section 1921, the first thing they tell us to look to is the former law. Now, the former law here, as it existed prior to the amendments to the Procurement Code in 2002, there's, I don't think, any dispute that the Board of Claims would have had jurisdiction over this matter because this was a contract with the Commonwealth that involved more than $300. And so the 2002 amendments to the Procurement Code are reducing the jurisdiction of the Board of Claims, and under 1928, that reduction has to be given strict construction, and under DataQuest, any reduction in jurisdiction like that has to be done through explicit language. It can't be implied or inferential. And I would submit to the court that in this case, because of the ambiguity over public building, public structure, to hold that jurisdiction doesn't exist, you would be doing just that, inferring. The next avenue under 1921 directs us to other statutes upon the same or similar subjects. And here, the Commonwealth Court, this seems to be the heart of their rationale and the heart of the Commonwealth's argument. The case law under the Separations Act and under the General Borough Code that construes provisions of public building or public structure in those statutes as meaning owned by the public or owned by the government. I'd submit to you that those cases are completely inapplicable here because they are not similar, because they do not involve jurisdiction. They all involved bidding for construction by jobs that the government was bidding out. They did not involve jurisdiction, therefore they're not dealing with the same subject matter, and they're not similar. The next thing I wanted to call the court's attention.
We're not gonna go on forever here now, so why don't you start summing up, please?
Oh, okay. Well, I would urge the court to review 1928. I would submit there's an ambiguity in the statute, and with a strict construction, jurisdiction exists. And for matters of public policy, like Justice Baer said, I believe my client is entitled to its day in court, and that the state should be held to account for its contractual obligations, and it shouldn't be permitted to breach them with impunity. Thank you very much for the opportunity to present this, and I'm very appreciative that you accepted this case.
Thank you, Mr. Durone. Mr. Adams.
Good afternoon, Mr. Chief Justice. It's an honor to appear before this court today. My name is Mike Adams. I serve as Chief Counsel to the Department of Community and Economic Development. And in that role, I also serve as Chief Counsel to the Commonwealth Financing Authority, which is an independent Commonwealth agency whose 7-member board includes 3 cabinet secretaries and 4 legislative caucus appointees. But we very much believe this is a sovereign immunity case, and as Justice Baer highlighted, the procurement code governs it. And in fact, the procurement code does not contain an express waiver of sovereign immunity when you have grant funds like this that are used in construction of private development simply because the private development or facilities happen to be open to the public. And in fact, the procurement code expressly reaffirms the important doctrine of sovereign immunity. And also in the procurement code in section 102 F, as was referenced, it specifically from the definition of construction, which thereby removes the jurisdiction of the Board of Claims. The alternative clean energy program under the CFA, which is the source of these funds, designates these as grants, not as procurement contracts. And in fact, the Alternative Energy Investment Act itself likewise does not contain any express waiver of sovereign immunity. Moreover,
Justice Baer,
yes.
And I don't want to interrupt your introductory statements, but you're going over awfully important matters. How does somebody who takes money out of the, whatever it is, the Alternative Energy Grant Program, I'm sure that's not the correct name, how, in the event that they get into a contractual dispute, where do they go to get it redressed?
Well, if it's in, it depends on what vehicle that is, Justice. If it's a procurement contract, then they have relief in the Board of Claims. If, as in this case, it's a pure grant, which is not an entitlement, and they have to follow terms and conditions of the grant, which unfortunately in this case, the grantee did not do, then they don't qualify for the grant. And based on sovereign immunity, they don't go anywhere for relief, to answer your question.
Can you tell me what this grantee did wrong that puts them, their view is that they got snookered by the Commonwealth? What's the Commonwealth's view? What did they do wrong that threw them out of court and out of their money, et cetera, et cetera?
Sure. The grantee did not follow the competitive bidding process to select contractors, which we here in Pennsylvania very, very much honor across the board, and it certainly was honored in this grant program. And then the other failure to comply with a material term is that the grantee was supposed to purchase the equipment and own the equipment. And here it turns out they leased the equipment. So so you don't have the same indicia of investment of public taxpayer dollars under a lease as you do with ownership. So it's those two specific reasons, Justice.
Counsel, Justice Donahue, if the General Assembly meant public to mean what you think it means, and as the Commonwealth Court, before I get there, do you agree that the term public structure is ambiguous?
Not as it is defined in Section 103 of the Procurement Code, because as you know, construction is tied to public structure, public building, public improvement, public real property. So I do not believe that it is ambiguous.
Well, let me ask you this. In Section 302, the legislature defined in the context of a public facility, a place owned or operated by a government agency. Now, that's perfectly clear what the legislature intended. Why not, if in fact they intended public to mean what the Commonwealth Court and you believe it means, why not use that language? Or as they do in other immunity contexts, owned, operated, or controlled by the government entity. And back to the other point about public facility being defined, they don't use the term public facility in the section of the act that we are now discussing. So if they intended it to mean what the Commonwealth Court says it means, why not use the language owned or operated by a government agency?
Well, Justice Donahue, I think that's an excellent question. And my first response is it's because the General Assembly doesn't draft perfect legislation. But what I will say is in this context, those provisions in there should be read in paramateria. I agree with you. It would be perfectly clear had the legislature drafted it as you suggest. Unfortunately, they didn't.
But
we see this all the time.
The bigger issue with it, if this is what they intended and they knew how to use those words, they didn't use it in the section of the statute regarding the grants that are at issue here. And should we presume that that's not what they intended?
No, I don't believe so at all, because again, you have to go back to the fact that these were grants, and grants are excluded from Aplt.
Unless they fit the section that we're dealing with here. I mean, they aren't.
Well,
as far as this case is concerned, that's the issue. I mean, does this fit the exception to the exception to the exception, which is what this is?
I'm glad you brought that up. I really appreciate that because, okay, so the exception to the exception, the only way they can be successful in this case is if they can somehow demonstrate that the grants were not really grants. They were, in fact, a procurement contract. But the only way they can show they're a procurement contract is if they are able to establish the elements that a contractor, the contractors who come in front of the state do and have to jump through all those hoops. Here's the key. The Board of Claims held an evidentiary hearing in this case and took facts. And this grantee had every opportunity to establish in front of the Board of Claims through a hearing that they, in fact, had the elements necessary to convert this grant into a procurement contract and just failed to meet that bar. And that's why the Board of Claims, basically, as one of the justices, and I apologize for not recognizing by name, as one of the justices just said earlier, this really hangs on public accessibility. And when that hearing was held in the Board of Claims, that's really what it came down to. It was publicly accessible, and there was no other indicia of elements that would convert it to a procurement contract. And therefore, the board, we believe, correctly concluded this was not a procurement contract. These were pure grants. I hope that answers your question.
Yes, thank you.
Justice Todd here. I have a foundational question, and it may be that I misunderstood part of your answer to Justice Donahue's question, but as I understood it, publicly accessible is defined within the procurement code, but public is not. And I thought I heard you say that public is defined in the procurement code.
I'm sorry if I misspoke. No, what I meant to say there was construction is defined in the procurement code under. So my apologies.
Okay, thank you.
And just
Sure.
Public facility is defined in the code.
Correct, just not
Correct.
public.
Correct.
Correct. Thank you. So we're all on the same page.
Okay.
Thank you for the clarification.
Yeah, thanks to both counsel for explicating their positions. We'll take the case under advisement and recess briefly and call the final case.
Thank you, Your
The next argument is Domus Inc. versus Signature Building Systems. Representing Domus is Ms. Maureen McBride. Representing Signature Building is Mr. Michael R. May.
Good afternoon. Under the Uniform Enforcement of Foreign Judgments Act, a party seeking enforcement in a Pennsylvania state court of a judgment secured in another jurisdiction must file an authenticated copy of the judgment in a county court. The controversy here concerns whether a judgment holder's failure to do so deprives the county court of subject matter jurisdiction. Ms. McBride.
Good afternoon, Your Honors, and may it please the court. Maureen McBride for Appellant Domus Inc. Your Honors, this is a simple case. The issue is whether a certification to the failure to attach a certification to a judgment to be transferred implicates subject matter jurisdiction or is a procedural issue that can be corrected. We believe that the Superior Court's decision is legally incorrect and contravenes this court's existing case law. And we also believe that Signature waived this issue by not putting it into its 1925 statement, and that therefore the judgment should not have been stricken. The Superior Court's decision conflates the concept of subject matter jurisdiction, which relates to the competency of the court to hear a case, a class of cases, with the court's power to grant relief in a particular case. There's no doubt that under our Constitution that courts of common pleas have wide jurisdiction over matters including these. So the issue here is that the Superior Court's decision took a procedural issue and made it a jurisdictional issue in a manner that's at odds with this court's case law. We cited the Beneficial versus Buckman case, which is in our brief, and that case involved a defective Act 91 notice in a mortgage foreclosure action. But this court analyzed the issue and the difference between jurisdiction, again, a class of whether the court has the general competency to hear a class of cases, with a procedural issue. And in that case, this court overturned the Superior Court's decision to find that subject matter jurisdiction in that case was lacking simply because there was a defective notice. In that case, the court also noted that the act, in that case it was Act 91, was silent on the issue of jurisdiction, and therefore it was error to embroider jurisdictional concepts onto the act. The same is true in this case. There's nothing in the Uniform Enforcement of Foreign Judgments Act that in any way limits jurisdiction. So the case of, also Buckman, also Commonwealth versus Jones, which is a case we didn't cite in our briefs, but it's a criminal case that's been cited a lot for the same concept. That's 929 A. 2nd 205. That's a decision out of this court where this court again analyzes the difference between subject matter jurisdiction and the power of a court to hear a case. And the Jones case involved a flaw in a bill of information, and this court held that it did not deprive the court of jurisdiction and could be waived. The Morrissey case, which we cited in our reply brief, also addresses this issue of if it's not in the statute, which it's not in this Uniform Enforcement of Judgment Act, then in that case in Morrissey, the court was asked whether the 4-year statute of limitations in Pennsylvania would apply. And this court, Chief Justice Saylor held that if it's not in the legislation, the General Assembly didn't intend it, and therefore it should not be, again, embroidered or placed onto the statute. In our brief, we addressed the consequences of this from a policy standpoint, if this decision is permitted to stand, because to allow the technical procedural error to become a jurisdictional issue would invite people to come in and look at judgments that have been transferred for technical violations. And if subject matter jurisdiction is missing, then everything that was entered is void ab initio and could be collaterally attacked in that manner. So it would open
if the court does have subject matter jurisdiction, what's the remedy other than reversal of the Superior Court
Well, Your Honor,
They send the case back to the trial court or the Superior Court?
Your Honor, I think the case would have to be sent back to the Superior Court because the Superior Court recognized that this issue, the lack of certification, was not in the 1925 statement. And I looked at it again today. It's not in there. And we know from this court's case law that if it's not in the 1925 statement, it's waived. But the Superior Court never reached that issue because it didn't believe it had subject matter jurisdiction. So I believe that the proper remedy would be to remand it, reverse and remand to the Superior Court for a determination of whether that issue had been waived.
Thank you.
Thank you, Your Honor.
It's an interesting court and horse problem because we have the record. The record contains the 1925B. The law is settled. If we determine that the issue is waived, then why don't we vacate the Superior Court? Implicitly, you have jurisdiction by virtue of the fact that the issue was waived, and we send it back for a merits hearing.
Well, Your Honor, yeah, I mean, the only basis for the Superior Court's decision was jurisdictional. Again, recognizing the court did that it was waived, I think it's plain on its face that this issue has been waived. It's clearly not in the 1925 statement. And opposing counsel has not argued that it is or is implicit in any of the issues that were raised. All of the issues in the 1925 were about notice. So I agree with you. I think this court, to streamline the issue, could find waiver just based on the face of the 1925 and vacate the Superior Court's decision, which would allow this judgment to then be enforced because that was the only basis for the appeal. It was a motion to strike. So,
But the Superior Court here in their appellate or original jurisdiction?
it was appellate. Its appellate jurisdiction. So a trial court.
So what did the trial court do?
The trial court denied the motion to strike, and that motion to strike was based on lack of notice in New Hampshire, which the court concluded, the trial court, that notice had been provided. The Superior Court then reviewed the issue solely with respect to the subject matter jurisdiction issue. So, but I think you could find that the issue has been waived and you could vacate that decision and affirm the trial court's decision.
And if we send you back to the trial court, that's where you want to be. You're going to get a merits hearing.
Well, Your Honor,
your judgment.
Well, there's already been a hearing. I mean, there's been an evidentiary proceeding in the trial court where the signature moved to strike the judgment on the basis of notice. The trial court accepted evidence, concluded that, and in painstaking detail, listed all of the notice that signature had been provided before the default judgment and the damages had been entered. So that's a collateral attack now on this judgment, which our statute doesn't permit. When they got to the Superior Court, they raised an issue in their brief, for sure, raised it in the brief about certification. The Superior Court looked at that issue alone and said, we're deprived of subject matter jurisdiction if that certification is missing, therefore we can't address the issues.
Okay. Any other questions? Pretty straightforward.
I agree, Your Honor.
Thank you. We'll hear from Mr. May.
Good afternoon, Your Honors. May it please the court, my name is Mike May. I represent Signature Building Systems, the appellee in this particular case. I respectfully disagree with my opposing counsel and would urge this court to adopt the opinion of the Superior Court because the method by which Domus in this case elected to proceed was under the Uniform Enforcement of Judgments Act and under that basis alone. And I think there's an important portion of the statute under Section E which recognizes by the legislature when it first enacted this in 1965 and then again adopted it in 1975, that nothing in the act itself precludes a holder of a foreign judgment from filing an action to enforce that judgment under the full faith and credit clause of the United States Constitution. In this particular case, Domus has agreed that the only method by which it proceeded in Lackawanna County to transfer the judgment was by utilizing the act under Section 4306 of the Judiciary Code. That act mandates and requires that the underlying docket entries in the judgment itself be authenticated. And it didn't happen in this case.
Well, let me ask you this. We understand the argument is very well, but you see the issue framed for review. If you fail to authenticate the foreign judgment pursuant to the requirements of the act, and they are very specific, does that deprive a trial court of subject matter jurisdiction? How could that deprive the trial court of jurisdiction? It may be you win on the merits, but we have a holding of the intermediate court that said that trial court has no jurisdiction because they didn't authenticate the judgment. How did that deprive the court of jurisdiction?
For jurisdiction itself, Your Honor, and I think this is where a large portion of Domus's brief has been dedicated. Under Article 5, Section 5 of the Constitution, the courts of common pleas have wide jurisdiction. And that's not to be confused with the power to actually act upon something once it's brought there.
That's correct. So we would answer the question, framed for discussionary review, in the affirmative. It was error to so hold and reverse, unless I'm misapprehending your argument.
No, I'm making a distinction, Your Honor, between the competency of a court to entertain a matter and the jurisdiction that the court has over the statute that was elected by Domus to proceed in enforcing this judgment. And that's the holding that the Superior Court relied upon in Ward versus Price.
That's a different issue. They may have, just say they don't have jurisdiction is different than saying that, having jurisdiction, they have to do this or can't do this. Different issues.
And in this particular case, Your Honor, the conference of jurisdiction, the ability to act upon the application made by Domus was relegated to Section 4306 of the Judiciary Code, our adoption, Pennsylvania's adoption of the Enforcement of Foreign Judgments Act. In this particular case, they didn't comply with it. In the absence of complying with that, the cases that we've cited in our brief, beginning with Ward, including Webb, and even Ian Howard, that this court had itself spoken to in terms of the technical requirements of complying with the act, are requisites before the court has the power to act upon the application that has been made to it. And that's the distinction in this particular case. In the absence of having that, in the absence of authentication, it does not allow the court to have the jurisdiction to actually act upon the application that's been made by Domus in this case.
One final thing, and I'm not going to monopolize this, but I still think you're conflating subject matter jurisdiction and power to act, because Ward's different. If you look at Ward, the issue was whether or not the appellant's failure to strictly comply with the statute's authentication requirements allowed the judgment to be stricken. Ward had nothing to say about subject matter jurisdiction.
Well, I think in Ward, Your Honor, they relied upon the Colorado Supreme Court case of Griggs versus Gibson, and adopted the reasoning by the Colorado Supreme Court in that case, which said that in the absence of complying with the act, with the act in that case, that under those circumstances, the court did not have jurisdiction, and any action that the court took was void ab initio.
Thank you.
Before you conclude, do you want to comment on the averment that you waived the issue altogether and we never get to the merits because you didn't include it in your 1925B?
Two things, Mr. Justice Behr. First is that with respect to the issue of jurisdiction, this court has consistently held throughout its history that subject matter jurisdiction is something that is allowed to be raised at any time. That was recognized by the Superior Court, and the Superior Court also saw that it was an issue that was brought to the trial court at the time of the initial petition. So it's not something as though either the trial court, the Pennsylvania Superior Court, or this court has been lacking in notice with respect to the argument that's been made by my client.
Thank you.
Thank you. Thanks to both of you. With that, we'll conclude our argument list and recess to our administrative session.
Thank you, Your Honors.
Thank you.